hope it doesn't bother you. All right, 128653, State of Kansas versus Chelsea Dawn Estep. I might tell you, counsel, that we have read your briefs. We have read a memorandum of law concerning your case from our research staff, and we might have a question or two. So be prepared for that. Counsel for the appellant.
May it please the court, Chelsea Estep appears through counsel Casper Shire, Kansas Appellate Defender. Chelsea is also with us in the courtroom here today. Could I please have 3 minutes for rebuttal, Your Honor? Yes, please, Your Honor.
All right, you got it.
This court should reverse a child endangerment conviction which is not supported by any evidence that Chelsea's children were placed in danger. Chelsea admitted to having a personal amount of methamphetamine in her bedroom at trial, and that's it. The state's theory was that a potentially dangerous thing in a house with children amounts to child endangerment. If that were the case, any Kansas gun owner with children could be said to be putting their children in danger every day. The state has to prove more. For a felony conviction, it has to prove imminent peril to the life, body, or health of a child. And for a misdemeanor, it has to prove at least a likelihood of imminent peril. Here, the state's evidence came up short. This is a far cry from White, which involved toddlers locked in their room for 14 hours at a stretch, without food or water, sleeping in their own waste, choking hazards strewn all over the floor. And this court said in White that those facts amount to a close call on the question of felony sufficiency. The state has not addressed White in its briefing. The best explanation for the conviction in this case is an unredacted interrogation video. Jurors heard Chelsea, seemingly unprompted and out of the blue, deny selling drugs. The shadow that the possibility of drug distribution cast over this case denied Chelsea a fair trial and pushed jurors towards a conviction unsupported by the evidence. We do ask this court to reverse.
What do we know about the judge's finding in this case on the whether or not there was a fundamental failure here? It got a little
muddy is the word I would
muddy.
use.
Yes, thank
Yes,
you. So the judge never found that there was a fundamental failure.
certainly not explicitly.
Right. It suggested a limiting instruction and then said, no, that's not necessary. So do we have to know, I mean, what do we make of that? Do we need to send this back for the judge to tell us whether this was in the judge's opinion, it was a fundamental failure?
No, I don't think so, Your Honor. And here's why.
Mm-hmm.
The question of 6455 came up
Right.
when the state tried to put on the video, having not filed a 6455 motion 10 days ahead of time as required by statute. The state argued, well, it's okay that we can put on evidence that she's being asked about selling drugs and she's denying it because she's denying it. And the ruling was no, correct ruling, in my opinion, the ruling was no, you can't do that because that is a suggestion that she's selling drugs. It is. So that has to come out. The court acknowledged that this was 6455 evidence that can't come in. Now, ultimately, jurors heard not the question and only the answer. And that was a redaction mistake. That is 6455. And the court acknowledged that it was 6455. And you're right, it got muddied later because the court, I think, backpedaled on that a little bit. But that is 6455 evidence that should not have come in as a matter of law.
Right. But it was not an admission of a prior bad act. It was not any evidence of a prior bad act. It was her saying, I don't know why people would say that. I haven't done anything like that.
Right.
It is muddy. I agree.
And here's the thing. This separating the denial from the question really only makes it worse. Only guilty people deny things that nobody has accused them of doing.
Mhm,
And that is what this looked like to the jury.
mhm.
A completely out of context, out of the blue, well, I'm not selling drugs.
Uh-huh.
And that's not what it was, but that's what it looked like. And it had an outsized impact on the verdict in this case, Your Honor.
Mhm. Okay. But, and why did the court decides not to give an instruction because they thought it would, did the prosecutor argue it would do more harm? Where did the court come up with this idea that it would be more harm than good?
I think the court came up with that idea on its own.
Uh-huh.
And frankly, I don't necessarily disagree with it.
Uh-huh.
But it's problematic because part of the reason for saying we don't need to declare a mistrial in the first place is
we're gonna give
because
them-
we're going to give a curative instruction.
Mhm.
Then when it comes time to give the curative instruction, the judge, sort of talking her way through it, says, well, you know, this was a denial. She didn't say that anything happened. She denied that it happened. The cat's already kind of out of the bag on that. I don't see how giving jurors an instruction that they should ignore the fact that Chelsea denied selling drugs and not use it to reach a verdict is going to help. In fact, it's not gonna unring the bell. It's just gonna ring
And
it a
did
second
defense
time.
object to that? I mean, did the defense stand firm that, no, this is a mistrial? You need.
Yes,
Okay.
yes. Defense didn't really take a position on whether or not to give the instruction, but they did maintain the position that a mistrial was required.
Okay, thank you.
Do you think the instruction would have cured this error?
No, I don't. I think the problems that the judge noted with the instruction were valid. I think a curative instruction, like I said, rings the bell a second time rather than unringing the bell.
I'm trying to get a handle on how any of this information was material to the charge.
Right. It was and it wasn't, is the best answer I have. I think when we're
That pinpoints it.
I think if we're looking at this logically from a sufficiency perspective, you're right. It has virtually nothing to do with the charge because as a matter of pure logic, denying selling drugs does not make it more likely or less likely that Chelsea put her children in danger. Jurors, and that's the answer I have on the sufficiency end. Then we have the real world answer, which is that jurors are not looking at this in a purely logical way. And our case law on 6455 recognizes that, recognizes the very real threat that jurors are going to use this kind of information to do things like weigh down Chelsea's credibility when she took the stand and said that she didn't put her children in danger. To do things like punish Chelsea for the unproven, at least suggestion, that there may be drug sales that she's responsible for going on, even though that hasn't been proven, and in this case hasn't even been alleged.
I was struck in reading this record that this seemed awfully rushed.
Yes, I agree. And I think that's a big reason that it came up. And I think there were other remedies the trial judge could have taken to 6455 coming up last minute that would have been more appropriate than trying to rush the parties through doing redactions in 25 minutes, which was, this was not an unforeseeable result of asking
I
the
think that's very
parties.
fair. Something like this and you rush through it. You can't be surprised if there's some errors.
That's right. And ultimately, it was on the state to put this before the court 10 days ahead of trial and before defense counsel 10 days ahead of trial. That's what the statute requires. And there's a good reason for it. In cases these days, defense attorneys in discovery typically get, many hours of video dumps, and they can't show up to trial with redactions prepared for everything that the state might be wanting to put on when they haven't been put on notice of, which bits and pieces the state is actually going to
Did we
use.
legitimate rule that the whole thing was a mess and set it aside? That the admission was erroneous to begin with?
That the admission of 6455 evidence was erroneous to begin with?
Because it didn't follow the statute, did it?
It did not.
You point out, counsel, that there's a reason why it has to be given notice ahead of time, so you don't have any of this last minute
Right.
trying to put evidence before the jury and getting it properly vetted.
And frankly, the reason I'm struggling to answer that is because I didn't brief it that way.
I know, but I'm asking.
I don't think that would be inappropriate as a matter of law. I will acknowledge that I didn't brief it that way. I briefed it as a mistrial issue.
That's a fair answer.
But I do agree, and
You see my dilemma.
I see your dilemma. And honestly, Your Honor, I think the way it came up at trial is part of the reason I didn't raise it as a 6455, and the clock just went wacky. Just as you said it would, Your Honor. Part of the reason that I didn't raise it as a 6455 issue is because the parties addressed 6455. The court ruled, yes, this is 6455. It needs to come out. Everyone met and at least tried to redact the video.
Didn't she go kind of backwards on that later, though? Later in the record, she talks about, well, perhaps it isn't 6455.
She did, the judge did backpedal that on that a little bit when I think it was when during the instructions conference that you're talking about, when she said, well, really, this is a denial and not a, but that is A, inconsistent with the initial 6455 ruling, and B, just plain wrong.
So she'd already decided this was 6455 evidence.
That's my position,
Right.
Your Honor.
And the fact that maybe the whole sentence didn't come in or the whole couple sentences didn't come in doesn't change that.
And in fact, made it worse.
Okay.
I have one other question.
Don't, Chris,
So-
please go.
Are you is your position that if not for this, there wouldn't have been a conviction? Or do you think there was other evidence that a jury could have found the way they did
I think the evidence was insufficient
to overcome
our argument is the evidence was insufficient even with this coming in, but that it had an outsized prejudicial impact on the jury's verdict. Yes. Yes, Your Honor.
Any other question? All right, thank you. You still have your rebuttal.
Thank you, Your Honor.
And we'll talk about the instruction issue then.
Hold on a second, let's get. All right, now, go ahead, Captain.
May it please the court, Your Honor, State of Kansas, appellee by and through Deputy District Attorney Michael Sarah. Judge, I'd like to start with I'd like to address by addressing one thing.
By addressing what?
By addressing one thing first.
Okay.
Defense counsel is maintaining that the simple possession of narcotics does not constitute actual danger to the child. There was more evidence than just the possession of narcotics. The defendant was running basically a flop house by her own admission. There were people in and out of the place all the time who she admitted she did not know, several of whom were known drug users and thieves. Drugs were found not only in her room unsecured, but also in the back porch area where this Steve Ferris person was staying, ostensibly to get people to leave Ms. Estep alone. I don't have any idea what Mr. Ferris was doing back there, but police found open baggies of methamphetamine in that room. The defendant at one point also informed police that there were possibly anywhere from 10 to 11 children in her house at any given time as a place of refuge. I can't see how the defense can say with a straight face that there was no evidence, absolutely whatsoever, that the defendant's own actions placed those children in harm's way. Methamphetamine is a terrible drug. It is as dangerous as a gun. God knows what those children would have done with it if they'd come with it. And that was the state's theory. The second issue I have with defense counsel's argument is that trial counsel for the defense just doesn't have time to review all of the evidence and figure out what the state is going to use. I take some issue with that, Judge, because I am a former defense trial attorney. I always made sure I understood what the state provided to me in discovery in anticipation of what they may use, so I may form my objections and I may form my motions. So I'd ask the court to give that absolutely no consideration. Now, the way this thing came up with the redaction, the defense, before it was about to be published or introduced, objected on 455 and hearsay grounds. Now, having the benefit of the cold record, the objection wasn't 455, it was relevance. That's what it should have been, because as you pointed out, Judge Hill wasn't material to anything. She wasn't charged with sale. But he raised it as 455, and I maintain it's not 455. Judge Rios did indicate the implication that she was selling narcotics. I don't want the jury to hear that, so redacted. And then when she had to analyze the motion for mistrial later, said it really isn't 455. She's just denying an accusation. She asked the defense counsel if he wanted a limiting instruction. He said, he didn't really adopt a position. So those are the two biggest issues I have with what the defense is arguing. There was more evidence than just the simple drug possession. These children were placed in harm's way. Additionally, defense counsel is not excused from missing something in a redaction issue because they just didn't know what the state was going to present. Now, as to the statement itself, it was pretty innocuous. It was a denial. And I dispute that only guilty people deny accusations. I've had clients, innocent clients, who've denied accusations too, and I don't consider jurors that cynical and that biased to just say, oh, they're denying something, so they must be guilty. We instruct them specifically that is what they are not to do. They are to presume innocence unless they are satisfied by the state's evidence of guilt beyond a reasonable doubt. With regard to and I know the court hasn't asked me any questions about it, with the issue of child endangerment having to prove there was imminent peril. That comes from a misdemeanor child endangerment case and a jury instruction issue. I put in my brief, there have been other times they've tried to graft the Cummings rationale into the ag child endangerment on constitutional challenges or void for vagueness challenges. Those have all been rejected. Now, I know counsel disagrees, says those shouldn't be tethered to each other, but the analysis is the same, is what does the state have to prove? And for reckless child endangerment, the aggravated version, there has to be proof beyond a reasonable doubt that the children were actually placed in harm's way, not a reasonable probability they may have been based on an unreasonable decision by a parent or anybody who has, caused those things to happen to the child.
So you're saying the aggravated endangerment charge already has a stricter requirement than the lesser, because the lesser is, in defining reasonable probability, would be placed in imminent peril, and the aggravated child endangerment is endangered.
Correct.
So is there any difference between is endangered and is in imminent peril?
I think the distinction
Aren't
comes.
they, I would say they're the same.
There's a probability test that goes into the misdemeanor version. And it's interesting too, because the misdemeanor version of this statute has a higher culpable mental state than the felony version. The difference always seems to be is the felony version requires actual endangerment. There has to be proof they were actually endangered versus a situation where the person may have placed them in a situation where there's a reasonable probability. So I believe the aggravated version already puts not only
I
defendants
think I'm
on.
agreeing with you
Yeah,
there.
no, that is my roundabout way of saying, yes, Your Honor, I agree. Those were the two big issues in the brief. I tend to write far more than I speak. So if the court has questions for me, I'm happy to continue speaking and addressing issues.
You don't get in trouble for not taking all your time.
Oh, I know. I don't want to waste the court's
Yeah,
time.
I
If
know.
you guys have questions for me, I'm happy to continue talking, or I'm happy to stand on my brief.
It's up to you, counsel. It's your argument.
Yeah, I don't think we have any questions.
Okay.
We understand your position.
Okay, very good. Thank you, Your Honors.
You've got your 3 minutes, counsel.
Thank you, Your Honor. The state still has not addressed White and the facts of this case as they relate to White, which was a close call on felony endangerment. The facts of this case don't come close to white. What we have here is methamphetamine in a house.
Mhm.
We have this unarticulated feeling that methamphetamine can be dangerous, therefore these children were in danger. We're missing a step in the middle. There's nothing to take us from, well, there's a possibility that this could be dangerous. If X, if the kids get into it, maybe it's dangerous, to actual endangerment. That was not in the trial evidence, and the state still hasn't articulated any theory that gets them there.
Was the danger only related to the drugs? I think the prosecutor has indicated it was way more than just drugs here. The house was in disarray. There were all kinds of people coming and going and children and no kind of supervision, or is that go into an endangerment determination too?
No,
Okay.
for two reasons.
Judge, I'm sorry, I apologize for interrupting. I'm hearing commentary from the gallery.
Oh, I didn't hear any. I'm sorry. No, I'm assuming you mean it came from this
I
end.
came
Okay.
behind me, Your Honor.
Okay.
Just like, hear you.
No comment. You can't make any. Okay. She understands that.
Sure. Two responses, Your Honor. First of all, the danger has to be to the life, body, or health of the kids. Life, body, or health. The state equally never articulated a reason why Chelsea's housekeeping was causing a danger to the life, body, or health of the kids. Why Chelsea having lots of guests was causing a danger to the life, body, or health of the kids. Why Chelsea's bicycle habit, which came up at trial too, was a danger to the life, body, and health of the kids. And that takes me into the second point, which was boiling underneath this endangerment trial was a second trial, which was essentially a referendum on Chelsea living up to the state standards of what they think a mother should be. That's a large part of what was going on at trial, is that the state didn't think Chelsea was cutting it as a mother. They put on as much evidence as they could to support that theory. The record is almost completely devoid of any evidence about the children or danger that they were placed in. We know virtually nothing about that. This was a trial about something else in which we injected unfounded denials based on unfounded accusations that Chelsea is selling drugs and came up with a completely unjust child endangerment verdict that we are asking this court to reverse.
Okay.
Counsel?
And the evidence that I,
Any other questions?
yeah, the evidence I have noted here is that they recorded video footage to document the living conditions, including methamphetamine and smoking devices in plain view in the master and porch bedrooms. So you're saying there's no evidence that any of those children would have ever been in those rooms? Or if methamphetamine is in plain view in those rooms?
Right, and a lot of that methamphetamine would have belonged to the co-defendant.
Well, it doesn't matter
Chelsea,
who it belongs to, does it?
well, in a sense,
Is it out in the open where these kids are? She's responsible for the home.
sure.
Mhm.
I think it's telling, Your Honor, though, that, you know, I did some sleuthing on the public access case system, and the co-defendant for possessing methamphetamine in the
Okay, I
home.
don't think we need to hear that if it's not evidence in this case.
Well, I think it's backstory, but if you don't want me to get into it, I
No,
won't.
I don't want any backstory that's not part of the evidence in this case.
Okay.
But the point is I guess, I agree. It's not child endangerment to be a bad housekeeper and to have a house in general disarray. But if you also have methamphetamines sitting around to areas in which those children have unfettered access, and maybe there wasn't evidence that they have unfettered access to those areas, wouldn't that be a concern?
At most, it's a misdemeanor endangerment concern. If something
Because
happened,
it's the
if they got,
possibility and not the actual.
if they got into it, then there would be a potential of danger. We would argue that it doesn't even rise to that, but it certainly does not rise to the level of actual endangerment.
So there should have never been a. And the jury was given that option. I mean, they had the lesser included. They could have.
They
convicted.
did. There were a number of things, and we've talked about them, so I won't dive into
Okay.
it again, that drove them to the felony conviction, I believe, Your
Mhm.
Honor.
Comes-
And I see that I know I'm long overdue, so that is all I will say, Your Honor.
Okay, thank you.
Thank you, counsel.
Okay.
We will take that under advisement and issue a written decision in
Thank you.